Hey, so today we're going to talk about employment law basics for public libraries, and I want to kind of start with my standard disclaimer. This is Claire Membiella from the Library of Michigan. I am the library law consultant. Everything we're going to talk about today is meant to be information for you. It is not meant to be legal advice, particularly with employment law. Employment law can be very, very complex, and like almost every law, area of law rather, it's very situational. So it's very hard to give you kind of a rule, or like what we used to say in law school, a black letter rule, that applies in every situation to every person. There are definitely some laws that are strict and apply, but how some of these laws apply and how they guide your actions can be very situational depending on the facts on the ground of what's actually happening. So a lot of what we're talking about today has to do with mitigating problems, how to set up your procedures and your policies to prevent problems. And we're not going to talk as much about what to do once a problem hits. There are some future webinars planned for things like a detailed discussion of grievances and discipline policies. But for today, we're really going to kind of focus on mitigation and what you can do to kind of prevent some problems and how your policies in general should be set up and some things to watch out for. As everything, if you find yourself tangled in an employment issue, your attorney is really your best friend in that situation. It's well worth the money. I know that some libraries are hesitant to employ attorneys because of the fear of the cost, but I can guarantee you that a good session with your attorney on an employment issue is going to be much cheaper than a lawsuit. So it's definitely worth the money to kind of confer when you feel you need to. Okay, so employment law encompasses a wide range of things. So it has to do with the whole recruitment and hiring process, any job descriptions or job postings you have in place, employee conduct policies, so how an employer expects their employees to behave on the job or in the workplace, and that can cover things like harassment and sexual harassment and bullying and a whole wide range of
Butter,
things.
how you doing?
Somebody does not have their microphone muted. If everyone could do me a favor and check and make sure that their microphones are muted. We are recording this. So if everyone could mute their microphone, that would be great. Thanks, I appreciate it. If you have any trouble doing that, just let me know and I will help you out. Okay, I see that there is one person who is saying they cannot hear. Oh, now can hear. Okay, all right, good. Okay, so then we have things like discipline, grievance policies, and procedures, which are very often the very sticky part of employment law. Nobody likes to be in a position where you have to discipline an employee. Nobody likes to be disciplined or be in a position where their board or their supervisor is looking at them with less than appreciative eyes. So that's very often where a lot of the problems come up. Then there are things like termination and exit policies and procedures. When do you fire somebody? How do you fire somebody? How do you conduct their actual physical leaving from the workplace? In terms of security, obtaining things like passwords, getting rid of email addresses, files, not to mention their own personal effects and leaving the office. Compensation and benefits policies. How do you determine who gets paid what? How do you, manage things like varying levels of management? Especially if you're in a situation where everybody has the same degrees or the same education and very close experience. How do you manage paying one person more than another? Can you pay one person more than another? Benefits policies, what do you have to offer? Do you have to offer anything to employees? What's the pros and cons of that? And then it's important to note that very often you hear the terms employment law and labor law used interchangeably. Employment law is specifically law dealing with the workplace. Labor law is law dealing specifically with unions. So labor law connotes that there is a union involved, that there is a collective bargaining agreement, and sometimes those situations have law rules that are slightly different than the standard workplace. And although employment laws would cover unions and labor situations, as I said, in certain situations, there are labor laws and labor agreements that may circumvent or may lay over employment law. So if you are in a union situation, there are some areas that we're going to talk about today that you're going to have to be you're going to have to be very aware of your union contract and of your, your collective bargaining agreement or any other procedures that your union has, because that's, in many instances, that's going to kind of be the decider for some of the stuff we're going to talk about today. There's also separate cases. There are separate administrative decisions, all based on specific union, like the NLRB stuff. And there are some state decisions that are based solely on union information as opposed to non-union situations. Because we are not going to be able to discuss everything today, our discussion today is really going to center on a few specific things. We're going to talk about public employment versus non-public employment. We're going to talk about at-will employment. So many of you might have heard about at-will employment. There's a lot of information going around about that, and there's some important things you need to know as an employer about the limits of at-will employment. We're going to talk about job descriptions and postings for jobs. We're going to talk about hiring and recruiting and evaluations and conduct policies, and then we're going to dip into discipline and grievance policies and procedures. But like I mentioned, we're going to really kind of concentrate on mitigation and things to watch out for. And then a later webinar will delve a little bit more into that in detail, because we could spend hours talking just about discipline and grievance policies. Okay, let's first talk about policies. When we talk about policies, which you're going to hear a lot about today, because a lot of mitigation of labor problems or employment problems really have to do with having good, solid policies. So policies, as many of you probably realize from having worked in libraries, policies play a very important role in a lot of aspects of libraries. But when you talk specifically about employment, policies they protect the library, they protect the board, and they protect the staff. So whether as an employee or as a manager, having policies and procedures written down and approved by your board and hopefully reviewed by your attorney gives you a measure of comfort and security that the measures you have in place and the procedures you have in place are good and are going to protect the library from litigation if they're followed correctly. So it gives you kind of a lodestar, it gives you something to hold on to when you're in a situation, because let's face it, a lot of times employment situations can be extremely nerve-wracking and they can be very stressful. So having written guidance there to kind of let you rely on can be very, very important. You have to make sure that your policies offer due process. Now that's every policy in the library. But what we mean by due process is, so every policy has to have notice. And that means that the people that the policy applies to have to know about the policy. So you have to make sure that your employees are aware of all of your... I'm sorry, someone still doesn't have their microphone muted.
Give the kids a chance to
If there is a way that somebody could
And
please
then
mute their microphone,
how do the other ones
that
that
would be really helpful.
doesn't have their microphone muted?
Okay, it actually looks like I can do it from here. So I'm going to go ahead and mute some microphones that I see unmuted, just because we are recording this and it's causing some, I can hear some people talking, and it's just like a classroom situation. It's a little hard to talk over, and I'm afraid that the recording will show that. So I apologize. So you want to, as far as due process go, you have to make sure that your policies, and everybody knows what the policies are, that all the employees are on the same page as the employer as to what the expectations are. And that's really what the policies do. If a policy is written correctly, it's going to put everybody on the same page with regards to what is the expectation of the employer as far as conduct in the workplace, as far as what the employer considers to be satisfaction with job performance, as far as what the employee considers what is their job and what are the responsibilities they have, and how to act within the workplace. So you have to make sure everybody knows it, whether it's through a job handbook or an employee handbook, or whether it's through a website. But however you do it, you want to make sure that your employees know, and part of that probably is also a good orientation process. When you do come into problems, you want to make sure that there is a good investigation process. That is also part of due process. You can't accuse people without having some kind of basis or some kind of reasonable suspicion. So if there's a complaint against somebody, there should be some kind of reasonable investigation. If a patron complains about a staff member with something that the director or the supervisor considers to be serious enough to warrant a discussion, then there should be some investigation about that. It shouldn't be just, we're going to take everybody's word over the employee's word. There really should be some investigation on, if you're going to ping somebody or you're going to discipline somebody based on something, you kind of owe it to them to do a reasonable investigation. Just like you would want done on yourself if that was a situation. So the board as well, if they're looking at something with the director, they should definitely do an investigation. If I get called in a lot of director issues and board issues and staff issues, and if you have a situation where the board is kind of coming down on a director, and it's just solely based on the words of a staff person, and there's been no investigation either with other staff people or with the director, no one's spoken to the director, or no one, there's no due diligence, and that's kind of not a great way to be a manager. And then you also want to make sure that there's an appeals process, so that either the staff member or the director has a way to appeal a decision that they feel is unfair. And that can either be through the board. As far as the director is concerned, it could even be through the municipality, or it could be through a subset of the board. So a lot of it could depend on exactly how your library is set up. Legal, you want to make sure your policies are legal. So you want to make sure that your library attorney reviews your policies, and that's with every policy. You should have when you create a new policy, you should just have your library attorney just take a look at it to make sure there's nothing in there that raises red flags. As I say, it is very much worth the cost, and it usually doesn't cost a tremendous amount. Most of the attorneys who practice library law and practice these areas of law have been doing it long enough that it doesn't take long for them to take a look at it and note anything that might be a problem. You want to make sure that you institute training for staff on compliance, enforcement, and implementation of policies. Directors and boards may completely understand what a policy is and exactly what the purpose is and what they hope to accomplish with it, but staff may not be on the same page, particularly if you have a lot of part-time staff. So you want to make sure that all your staff, any staff member that's either going to be held to a policy or is going to be responsible for enforcing a policy really should understand what those policies are, how the institution expects enforcement to be handled, and what other procedures may be involved. Are there incident reports that need to be drafted? Is there a memo or an email that needs to go to their direct superior if something occurs? If there's an issue between two staff members, does the director want to know about it? Does a note need to go if there's some kind of problem? So that should all be noted in your employment procedures or your employee conduct or wherever you feel it's important to go. You want to make sure all of the policies are clearly worded so that there's no doubt about what the purpose of the policy is and how the enforcement of that policy is going to work out. You want to make sure that any implementation of new policies are organized and transparent. And this is mostly geared towards if you're a new director, a director, what I should say is if you're going to a new library, so whether you're an experienced director or whether you are a new director, when you go into a new position, one of the most common scenarios that I have encountered that tend to be an employment issue is when you have a change in an organization. So it could be a new board member, it could be a new director, it could be a staff change. But whenever there's new people, there's bound to be change, right? So new board members like to put their stamp on things, right? So you get a new board president and chances are there's going to be a review of procedures, a review of policies, and there may be some change implemented. Now, it doesn't mean that that change is bad, but most of us don't like change. And if you've worked in a position for quite a while, usually you really don't like change. So if you're a staff person that's worked in a library for a fair number of years, and then you get a new director who comes in and then wants to make change, well, that's perfectly understandable from the standpoint of the director, right? And it's healthy because it's good to have change in an institution. But it causes problems because employees can be very intimidated and threatened by change. So if change and new procedures are implemented in an improper way or in a clumsy way, it can cause huge ramifications. There can be a huge domino effect that can result in some real problems for both the director and the staff involved and the board. So when you're implementing new policies, it really should be done in an organized and transparent way. And a lot of times what that really boils down to is communication. So it's communicating to staff why there's a change, what prompted the change, what this change is hoping to accomplish, and hopefully involving the employees in the change so that they feel vested in this change and it doesn't feel as much like it's being imposed upon them. So, and the same is true of library directors, right? So if a board comes in and wants to change things, all of us like the idea of being involved in whatever change may be inflicted. And all of us like a say in when there's going to be especially substantive change. And so those are just kind of good policies. And the more you do that, then the less chance you have of an employee looking to find fault with a new director, with there being bad feelings, and then there's gossip, and then there's, passive aggressive behavior, and there's employees who, some will go and then start complaining to board members about the director. And if the person's been there a long time and the board's been there a long time, you can see how that can turn into, and it does turn into, a whole thing. So communication and transparency can solve a lot and can really help with establishing trust, which is really a lot, and respect, which is really what a lot of this is about. You want to equally enforce all policies. And now this may sound like obvious, but you'd be surprised. All of us, there's been a lot of talk lately about innate bias and unconscious bias. And unconscious bias doesn't only apply to situations with race or sexual orientation, but it can apply to situations where you've worked with a group of people for a long time and then a new person comes in. And then there can be unconscious bias towards the people that have been working there a long time. And people who, employees who and you trust. If there's employees that, do a great job, we all have been in workplaces where we know employees that are just the solid workhorses of the library. And they do amazing work and they're very good at what they do. And they have personalities that are just phenomenal, right? So they're the perfect employee. But then you have to really think nobody is perfect, right? So no matter how good an employee we have, everybody has some areas that they can improve on, and everybody makes mistakes once in a while. So one of the things that supervisors have to be careful of in terms of trying to avoid problems later on and litigation is this idea that if you're going to enforce a policy, you have to be willing to enforce it across the board. So if you have a policy, and this, my background is academic libraries, and for a lot of years this was, the situation where you couldn't bring liquids into the library, right? So you could not have a drink at the reference desk. And if you're on the reference desk for several hours, that can be really, uncomfortable. So there was, for a while, there was, this issue where some people would just do it and not get pinged on it, and other people would get pinged on it. And so that's kind of a circumstance where, if you're going to have that policy, now whether that policy is a good one or not is a whole separate issue. But if you're going to have a policy, you have to enforce it across the board. You can't say, well, this person is older and needs liquid, so they can have liquid at the desk, but this other person can't. Unless, again, there's like an ADA accommodation or there's a real legally based reason. All that's going to do is make the employer look like they have favorites. And then the people who perceive themselves as not being favorites are going to start looking at the employer as, okay, now I am being negatively treated and I am being unfairly harassed because I'm being made to adhere to policies that other people don't have to be adhered to. So, those are things to consider. All of us have to make judgment calls in the workplace, and I'm not saying that every deviation is wrong, but what I'm saying is that this is something that you should consider when you are creating policies is, can you enforce this uniformly? Because if you can't, then that's something to think about that policy and think, okay, why do I want this policy? And is it going to be worth it? So you don't want to create policies just for one staff person. You want to make sure that you support each other. So what I mean by that is staff should have each other's backs. The board should have their staff's backs. The director should have their staff's back, and the board should have the director's back. And to a certain extent, the director should have the board's back. Okay, so all of you are partners in working in the library. And there needs, one of the most important things in public libraries is to work to establish that trust and respect between the board and the director, the trust and respect between the staff and the director. And there should be trust and respect between the board and the staff, but we're going to talk about that in a little bit because that's a little bit different. So you want to make sure that, if a problem arises, like I said before, and you want to make sure it's properly investigated. So a board should not automatically feel that the director is at fault, right? If they get a complaint. If a member of the public complains about a staff member to the director should say, oh, I'm so sorry this happened, I will investigate it, but should not automatically assume that the member of the public is relaying that complaint in a completely, I don't want to say truthful because it doesn't mean that the person's lying, but sometimes witnesses are not always accurate. And the same is true of the board. If the board gets a complaint from a staff member, the board really should, the first step should be referring that staff member back to their supervisor. Thank you for telling me this. There's not really anything I can do about that right now. You need to talk to your supervisor. The board should definitely not step in between the staff and their supervisor, whether that supervisor is the director or whether that supervisor is a middle management librarian that then reports to the director. So the first step should be sending the employee back to their immediate supervisor. Okay, so now we're going to talk about public employment. And I'm having, oops, sorry about that. Okay, so we talked about labor versus regular employment, and now we're going to talk a minute about public employment versus non-public employment, or versus, you know, private employment. So a public employee, according to the several areas of the Michigan compiled laws, and on the top of this slide is the statutory section from Chapter 15 with public employees. And it has to do, this is where you'll find the Open Meetings Act, this is where you will find the Open Meetings Act, this is where you will find FOIA, this is where you find a lot of kind of the ethics kinds of acts, the Incompatible Offices Act, they're all under Chapter 15. So the definition of public employment and public employee in this chapter indicates that anybody who's an employee of a municipality or an employee of a board, agency, institution, commission, authority, division, council, college, university, or public entity of this state or of a city, village, township, but does not include a person whose employment results from election or appointment. Now, I want to address that for a minute. So that may make you think, well, then my board who's elected or appointed is not a public employee. Well, the boards are public officers, and so there's a separate definition within that same chapter for them. So they are constrained by the same rules that you guys are, that public employees are. They just call them something different. And in fact, they are constrained by more. So libraries are clearly included within this description, because every library in Michigan is either a subdivision or political subdivision of a municipality, or constitutes an authority or municipality in and of itself, which is, you know, a district library. So one of the things to consider with public employment is that there are certain rules and laws that apply to public employees that do not apply to private employees. So if you were to work at, you know, Target, or you to work at a private school, or you were to work at some other institutions, you would not, like a private museum, you would not be constrained by some of the same laws that you are under public employment. For example, restrictions on the ability to campaign politically. Right now, we're in an election year for president. It can be very tempting to wear your political buttons to work. In a lot of public employment situations, that's not considered appropriate. You can wear the buttons as a private person. So if you go out on your lunch hour, you can put your button on, but when you step back into the library, you should not be wearing your button. That's why you cannot, within the library, advocate for passage of the library millage. You can provide information about the library millage, factual information, but you cannot wear like a yes button or vote yes for the library. You have to be careful with public money. There's laws that, you know, mean that employers in libraries can't have parties for their employees and pay for them with library funds, cannot give Christmas presents and pay with library funds, cannot make donations or buy flowers for retirements or funerals with public funds. But if they have a donor, like a friends group, that gives them money that's specifically earmarked for those purposes. So for example, your friends group gives the library money and it says this money is for employee recognition, or this money is for you know, activities relating to parties for employees, or employees who retire, then that's fine. But you can't use, if the friends group just hands money to the library, those funds are considered public monies, and that's not something that can be used for those purposes. So that's, you know, a rule that holds in the public sector, but not in the private sector. So there's, you know, all kinds of different things that, you know, can impact this idea of holding more than one public job with the incompatibility. So the thing is, there are some additional responsibilities of being a public employee as opposed to being, or a government employee as opposed to being a private sector employee. It is important that if you are a municipal library, so not a district library, if you're a library other than a district library, it's important that you take note of any municipal ordinances that could affect your employment policies. So some municipalities have restrictions on nepotism, for example, or have ethics ordinances that dictate a certain kind of behavior that's expected from employees of that municipality. Those rules, those laws would apply to, arguably would apply to library employees. And that is something that maybe you would want to talk to your attorney. We're going to talk in a minute about municipal employees versus non-municipal employees, but generally speaking, if your library was created by a municipality, there may be, you may have to adhere to these ordinances that deal with nepotism and ethics. So that's something that's, even though you may not be considered to be specifically city employees or village employees. I see there is one chat person. Can public employees advocate for IMLS funding? Public employees cannot, actually that's a really good question. I might have to get back to you on. I know that you cannot advocate for state funding, but I'm not absolutely sure about the federal funding. I know that you know, that's a good question. I am thinking that you probably can't, but I will look at that and I will put that in the email that I send to everybody afterwards, because that's a good question, whether you can advocate for federal as opposed to state. I know you cannot advocate for state funding, for state, and actually I'm thinking you can't, because you can't put, you know, advocate for presidential candidates. So I'm thinking you can't, but I'm going to double check it just to make sure, so that I don't give you the wrong information. So let's talk about municipal employees versus non-municipal employees. So there are 10 library establishment types in Michigan, and of those 10, only 3 of these types automatically consider library employees municipal employees. So if you're a home rule city library, so if you're a city library where your library was created by, you know, a charter section of your city, but not under PA 164, if your board of your library is the city council, right? So if the city council governs your library and you do not have a library governing board, then you're probably a municipal employee. If your library is a department of the city by virtue of your establishment, now, not just because your municipality thinks you're a department of the city, but if by your true establishment you're a department of the municipality, then you're a municipal employee. So the 3 types that would fall under that is the home rule city libraries, if you're a charter township library, or if you're a PA 269 library, which is an old establishment type that's been repealed. And so if you're a general township library that is a PA 269 library, that is, you're not a PA 164 and your township runs your library, then you're probably a default municipal employee. For all other library establishment types, so that means if you're a PA 164 city library, whether you're a Section 1 city library with a 5-member board, and whether you're a PA 164 10A city library with a 6-person elected board, or you're a township library with a 6-person elected board, or you're a village library, then you by default are not public employees. You're employees of the library. And I know that there are situations where either the municipality decides you are public employees for right or wrong, or there are situations where libraries contract with their municipality. So there's a written agreement where the municipality agrees that the library employees can be municipal employees. Usually it's done for purposes of benefits. So there's a contract written up that permits the municipality to lease the library employees back to the library, but the employees are municipal employees so that they get benefits. And the library typically then pays for those benefits and pays for the payroll of those library employees. So the benefit is that the employees get access to benefits. Those situations which are occurring more and more often is the situation where you want to actually very carefully read the contracts, because you want to make sure that everybody understands who is going to be in control of these employees. So are the employees governed by the board and the director, or are the employees governed by the municipality and their chain of command? In terms of hiring, in terms of firing, what is the employee policies? Do they come from the library? Do they come from the municipality? So that's a very important thing to understand when you are in a situation where you're leasing your employees. So that's something that you need to know. If you're in a situation where you're not formally leasing those employees and you're a PA 164 and your municipality just thinks that you're municipal employees, that's a whole other question that you will want to talk to your attorney about. And if you want, you can call me too, and I can at least help you do the initial investigation, and then you can go to your attorney. But that's a situation that's kind of outside the scope of this, because arguably those library types, you'd be a library employee and not a municipal employee. So when you're a municipal employee, as I said, municipal policies would usually govern. So it's very important that the managers understand what are the policies, what are the procedures, what are the people that they need to talk to when there is the role of the board in employment matters. And this I'm going to go through pretty quickly. It's important to note that in Michigan, in every establishment type in Michigan, the governing board, whether your governing board is your municipality or whether your governing board is a separately appointed or elected board, is the boss of the library. And I know a lot of people don't like to hear this, but it's the law. The board is the fiduciary for the library, which means under the law, they're responsible for what happens in the library. It also means they have a duty that any decision they make with regards to funds or with regards to the library has to be done in good faith for the benefit of the library. So that's also an important point. They have a very strict responsibility under that, very strict well, I guess responsibility is the best way to put it. Now, the governing board is given authority by statute. So their powers come from the legislature. So depending on your establishment type, there are different powers that are enumerated for the boards in those establishment types. Directors are given their powers from the board. So library directors are giving their powers and responsibility are delegated by those library boards. It's the board's job to determine the director's role. Now, we all know there are best practices, and we all know that there are industry standards that, the Library of Michigan informs boards about, and library directors informs boards about. So, you know, and those standards are that the director runs the day-to-day, and the director manages the day-to-day employees and library staff. But at the end of the day, it's very important to note that the board is statutorily bestowed with responsibility for operating, for running the library, for making decisions for running the library. And that includes disciplinary actions and hiring actions. Now, there are several establishment types, specifically the DLEA, the District Library Establishment Act, and all of the PA 164 libraries, where you will see under the board powers, it will say that the board may hire the director and necessary assistants. So even though, again, best practices and industry standards and frankly common sense would suggest that the library director should hire their own staff, it's important that you know that there is statutory sections that does give the board the power to hire staff. So if that comes up, then that is something that as a director you would want to discuss with your board and indicate why it's preferable for you to hire. And you may want to make sure in your own job description advocate for that power to be delegated specifically to you, so that your job description or your employment contract specifically states that the director will hire and supervise staff, as well as any other particular power and responsibility that you feel is important for a director to have. Policies, employment handbooks, and job descriptions, best case scenario, they should be drafted by the director, but they should be approved by the board. So again, the board as the fiduciary, the board as the person who's going to be left holding the bag if there's litigation, needs to approve those policies. They need to know what those policies are. They need to be able to approve them. But as I said, the director should draft them. So the director and the board really should be partners in this. The board is the director supervisor, but they really should be partners in making sure that all of the policies relating to employment and everything else are in place, are kept current, and are fully approved. Once you have a chain of command, and once you know everybody's responsibilities are in place, it's important that there is understanding that these chain of command will be followed by both the board and the director. So just like I mentioned before, just as the board should send any employee back to their supervisor if there's a complaint, the director should do the same thing. If there's a chain of command where the director has middle managers that report to them, and one of the staff members under the middle managers goes right to the director should send them right back to their middle manager. Now, there may be some, let us say, more serious complaints, violence, any kind of abuse, sexual harassment, that are those kinds of things that could rise to the level of maybe skipping chain of command. But those are the kinds of things that any good manager should be able to recognize. But your day-to-day sniping and complaining really needs to, you know, the employee needs to be sent back to the director or to their supervisor. One of the worst things in employment that can happen, and something that can really cause a lot of problems, is to disrupt that chain of command and allow staff and others to circumvent it. Okay, next one. At-will employment. Okay. So what is at-will employment? So at-will, generally Michigan is considered an at-will state. So at-will essentially says that the employment relationship exists at the will of the employer, and to a certain extent the employee. So that means that either party can break this relationship for any reason at any time. So there's no expectation of continued employment by the employee. So there's no, if I do a good job, I get to keep my job. So at-will employment is pretty much like, okay, you know what, we can just fire you for any time for no reason, and we don't have to have any cause to fire you. But at-will can be affected. So even though Michigan is a default at-will state, there are certain things that can affect an at-will status. What affects at-will status essentially is any situation where a contract may be formed between the employee and the employer with regards to keeping their job. So for example, if you have an employment handbook that designates a very strict discipline policy, or a very, there's 3 strikes and you're out, where the first thing is a verbal warning and then a written warning, and those can create a contract between the employee and the employer that says, okay, if I follow all these steps, then I'm going to be okay. And if I do my job, or if I have a performance plan and I follow through on that, then I'm going to get to keep my job. So the way that you mitigate that is on your documentation. If your board, and if the board and the director, if it's determined that you want to remain an at-will employer, because you don't have to be, it's up to you. If you want to remain an at-will employer, then your documentation, so everything from, if you have an employee portal on the website, if you have an employment handbook in paper, if when your hiring letters, you can even have a form that new employees have to sign when they join. And this essentially is a statement that says that you are an at-will employer, and the presence of any procedure or document is not going to affect that at-will relationship. So the form that your new employee might sign is just pretty much an acknowledgement that the employee understands it's an at-will workplace. So by making sure your documentation has these statements, you mitigate the possibility of creating that contract. Now, that doesn't mean that in certain situations, even with that statement, that you cannot still create a contract, but it greatly mitigates that situation. So it's the other thing to look at as a public employer, and this actually applies in a lot of situations, and I think it's something that many directors don't think about and many boards don't think about. So this is also something that should be discussed with your attorney. The only entity that can legally bind the library to a contract is the board. So because they're the authority of the library, they're the governing body of the library, and the statute specifically states that they can bind the library to a contract. This doesn't mean that the board can't authorize the director to bind the library to a contract, but that has to occur. So it's very important that the parties understand who can bind the library to a contract and who can't. And this is important for things like employment contracts with staff. It's also important for this at will. If you have, there are cases where middle managers have created employment relationships and arguably contracts with employees in an at-will situation, and then employees were fired and they came back and sued and said, well, I have I believe that there was a contract that I wouldn't be fired except for cause because of this procedure or because of this handbook. And the courts come back and said, well, your supervisor was unable to bind the library to a contract. So, regardless of that policy that, they set up, they can't bind the library to a contract, so there was no contract. And this is another reason why you want to make sure that your board reviews all of the policies. And again, it's probably worth it the next time you have your attorney to kind of just discuss that and say, well, what is my status with regards to binding the library to a contract? Again, maintaining at will. Make sure you have you can have an at will notice. Make sure your documentation includes at-will statements, and you want to make sure your board approves the materials. So job descriptions. Your job description should identify and summarize all job functions related to a particular position. They need to be objective, comprehensive, flexible. You want to make sure they include specific tasks and responsibilities, that they represent the work environment or the context in which those responsibilities occur. Like, for example, your chain of command, or the fact that you're a government employer. And you want to be very careful about including any criteria that could be looked at as limiting or discriminatory or having a disparate impact. So anything regarding age or race or religion, any disability, or anything relating to gender. So you want to be careful about saying that, job description is, a young, a youth librarian is youthful. You might not want to say has a youthful personality. Now, you may not mean that they have to be young, but maybe you're really talking in terms of their demeanor or in terms of their, approach to life. But you don't want to put that in there because it could be misconstrued. And that kind of takes us to why job descriptions are important. Job descriptions provide the way that employers tell employees, what the job is and what the responsibility of the job is and what is expected from them on the job and what constitutes a successful performance. It provides employees with their boundaries and their context to understand their role and their position within the structure and within the chain of command. It can also be used if you have an ADA issue, okay? So the ADA indicates that you have to have accommodations for people who can accomplish the essential job functions, but for, they might need an accommodation to do that. So for example, you have a reference librarian who is blind, but can, perfectly do the job with, a modified computer and some other accommodations. So an essential job function in that reference position might be using a computer and assisting patrons, but those would have to be accommodated, right? But if you had somebody who, because of their disability, could not do those essential job functions, it's important to know what those essential job functions are, because if you were to not hire somebody because their disability prevented them from performing those essential job functions, and they sue, the EEOC is going to look into what are the essential job functions. And so that's why a job description that's well written can be very helpful to the library in supporting their view of what is an essential job function. And then a job description can also be useful in when you have employee evaluations as their objective measure of performance. But one of the things a job description is not is it's been found in courts that an employee cannot use a job description as a contract. So they can't use a job description as saying, this is what I definitely must perform. So there are some idiosyncrasies to this too. Okay, hiring and recruiting. This is something actually that I think, like millages and like some other things in libraries and the workplace, we get used to cutting and pasting stuff. So you have an employee that has been there for a long time, and then they, for whatever reason, decide they're going to move on, and then you have to fill that position. It's very tempting to just take the prior job notice and just cut and paste into whatever format you use now. However, just like with millages and other things where you might do that, it's important to review that. One common thing now is to see physical requirements in a job notice. And that can be very problematic. All right, you really want to be careful about those physical requirements. The purpose of those physical requirements are really to provide employers with a mechanism to notify applicants that there may be specific physical parts of the job that are essential job duties. And so putting things in a job, not writing this carefully, and putting things in a job description for a library employee that say things like must hear, must see, must have, 20/20 vision, must be able to speak, can be very problematic unless you also include the phrase with accommodation. Because the effect of these entries in a job posting is you're pretty much saying we don't want any disabled or physically challenged applicants. And that has the either intended or unintended consequences of deterring that protected class from applying for jobs. And it has been shown to be illegal and discriminatory. So you want to be careful about writing those physical requirements. It's okay, to have them, to say that, the person must sit and stand, must reach, but because you want to make sure that the applicant understands the physical portions of the job. But you want to make sure that you also include in your job description that you welcome applications, that you're an equal opportunity employer, and that, insert that phrase with accommodation. So must have good vision with accommodation or correction. Must be able to hear or speak with accommodation, or a better way to say it is must be able to assist patrons with accommodation. I have included here a sheet from Pace University that goes into here's the physical demand, and here are some different ways to say this that are more inclusive. So I encourage you to take a look at that. If it's too tiny, I will put the link for this in the email that I send along with the slides this afternoon, so that you can get to it on your own. And I have some other really good examples of more inclusive ways to incorporate your needs into a job description. So I'd be happy to share those as well. So summing up hiring and recruiting, you want to make sure you know your local laws. If your library is a municipal library, make sure, like we mentioned before, you're aware of any nepotism restrictions and how far they go out. So nepotism isn't always just, sister, brother, child, mother. They could be aunts, uncles. Depending on the municipality, they can extend out a little ways. Doesn't include spouses, doesn't include the family of your spouse. So it's important that if you do have a nepotism restriction within your municipal ordinances, you want to make sure that you know how far that extends. Are there residency requirements for your municipality as far as staffing goes? Some have them, some don't have it. What about drug testing? What about criminal background checking? All of this can have an impact on your hiring. If you're a union employer, make sure that you understand the union hiring process and any requirements that are in your collective bargaining agreement. There's a big question about, and I see that we're almost out of time, there's a question about the box, okay, so about criminal records. So in Michigan, you can you can ask about criminal history as far as felonies, misdemeanor conviction, felony arrests, and felony convictions. But misdemeanor arrest is not something that you can consider. You also have to be careful about considering arrests because of the disproportionate effect on minority communities of incarceration. Just having a criminal record is not good enough to not hire somebody. So you have to be able to associate that criminal record directly with a threat to the job. So essentially, there has to be a pattern of, in other words, if number, nature, and proximity in time would of these arrests or of these convictions would cause the applicant to be unsuitable for the position. So clearly, if it's a sex offender with multiple offenses and jail time, maybe it's not good to be your, youth person. But you have to be very careful. You can't just reject somebody because they have a criminal record. And on this slide, I have some additional information on that because it's kind of hard to really, again, it's very detailed. So you have that. When I send those, you'll see those. Evaluations need to be, again, they really need to be clear. They need to be organized. The more objective they are in terms of ratings and not really personal evaluations in terms of like numbering system is probably best. You want to make sure it's consistent. I have some links here to some examples of performance reviews. You have to be, the biggest legal fear with reviews is inconsistency and favoritism and a lack of due diligence and investigation. And so that's why you really want everything well documented and the procedure really well laid out, and you want to make sure everybody is evaluated, not just a couple people. So it really should be a comprehensive plan and a comprehensive process to do that. Because an evaluation can be helpful and it can be not helpful. If you evaluate somebody and then 6 months later terminate them, but their evaluation was good, then the terminated employee can actually use that against the library in favor of an unfair termination. So it's really important that you kind of consider and think about your evaluation process, and that applies to directors as well as staff. You should have a good a good training and orientation policy for your employees to make sure they really understand the culture of the library and the rules and regulations and have that notice. Discipline and grievance, we are going to kind of, like I said, we're going to have a follow-up on this that's going to go into more detail. It's important that you know your union responsibilities. You want to make sure that you contact your municipality if you're a municipal employee. Again, you need clear policies, adhere to your chain of command. The most important thing is document, document, document. You cannot have too much documentation when it comes to the uncomfortable process of, something that might end up in someone getting fired in a discipline procedure. And that's true even if you have a performance plan. And you want to write these performance plans carefully, and you want to make sure that the library adheres to them, that the library very carefully follows its responsibilities. If there's dates that say the employee has to be re-evaluated, you got to make sure that those occur at the correct dates. You want to make sure the criteria is clear to the employee. You want to make sure the expectations are clear. You want to make sure you have all your T's crossed and all your I's dotted when it comes to performance plans. You want to make sure that as a director, you keep your board informed of what's going on. You're not a bad manager if you have an employee that's a problem. The more that you garner trust with your board and transparency with the board, the better it will be for everyone. And the same is true of the board. The more the board encourages that transparency, the better it is for everyone. And last note is please make sure that you contact your library attorney if you have a problem. And that's because job employment law, like I said, can be very complex, and it can have really serious ramifications if things go wrong. So it's very important that if you are in a situation with an employment problem, contact your attorney. If you have a sense that you should, I would, and it's very much worth the cost. And if you're really nervous about it, you can contact me, and I'll be honest with you. If I, see, and I'm like, you really should contact your attorney, but I can also help you at least with some research and some information. But it's not worth a lawsuit. Just to, it's definitely can give you a lot of reassurance by contacting your attorney, and it can really help you forge a plan in the right direction. Okay, that's everything. I see that I am 7 minutes past, so I apologize for that. But this is just an area that is there's so much to talk about that I think, have to follow up with a part 2. Please don't hesitate to contact me if I can ever be of assistance. I have a survey that I will be sending you this afternoon as a follow-up. If I see there's 3 chats, I'll take a look at them. If there are questions, I will copy the chat questions into the email and answer them so that everybody has that information. And I hope that everyone has a great day, and the weather's supposed to be kind of cruddy, so I hope that you have a good rest of your week. I see that there are, several chats here, and there are just a few questions, so I will copy those into the email that I'm sending, and I will answer them. Thank you, everybody, for your patience. I'm sorry I went a few minutes over. Like I said, there's just a lot to discuss, and I will send you my slides this afternoon, and I'll let you know when the link goes up. It should be up by early next week. Thank you very much. Stay safe in the snow and have a great rest of your week.